me tell you about a story. Now women are talk bound about their law enforcement, a right bunch of clowns, how they wear their badge like a plastic crown, how they're sticking to a story of which they are now bound. It's a rabbit hole they don't want you to go down. But over in Wisconsin, they're doubling down. See, they framed them once, then they did it again. They did not count on filmmakers making MAM. They thought their lives were safe, all would buy the ruse. They did not figure on 19 million views. It'll make you shake your head and probably frown. But over in Wisconsin, they're doubling down. I said they'll double down, and they'll triple down. They're headed down a road which they cannot turn around. They walk around like they'll be home free, because they control all the evidence on the local judges and found is the state's AG. But I got some news. It's as plain as day. It doesn't matter what the state or the guilters say, because we got Kathleen. She's got them in her sights. She's a real live hero, turning wrongs to right. No matter how hard that state's gavel pounds, over in Wisconsin, they're coming down. I said no matter how hard that state's gavel pounds, that house of cards isn't coming down. It'll make you shake your head, probably frown. Said over in Wisconsin, they're coming down. Over in Wisconsin, they're coming down.
He's innocent. The day always comes if you're innocent.
Hello, everybody. Hello, everybody. How you doing? I gotta get my sound turned back on here real quick. All right, there we go. Hello, everybody. How you doing? It's good to be here today and see all of you, obviously out there tuning in. Today, Mr. Travis Williamson and I are going to be talking about the motion for scientific testing that was originally filed by Kathleen Zellner back in August of 2016. Basically, the first thing she filed, essentially, well, the first major thing. And so we're going to be going over that today. We're going to be showing you basically the document itself, maybe some other documents. And so this, we hope this will be very interesting. Hello, Travis, you there?
I'm here. Can you hear me?
Yes, we can hear you. Great. So welcome to the live feed.
Thank you for having me.
Hello to everybody in the chat. How you doing? Everybody saying hello. Somebody liked the puppy in the during the song. So Spicy says, "Hey Trav." So sorry, as I was telling you, we're here to kind of just go over the motion for scientific testing that was filed in August of 2016. What we're also kind of going to be leaning on while we're doing this is kind of the progression and the evolution of Stephen's case with Kathleen Zellner, how some things have changed, some things are the same, but some things have changed, and how that kind of metamorphosis has been taking place. We're hoping to kind of showcase that here in the coming week. We're going to start by covering the motion for scientific testing, of course, and then hopefully this week, splitting it up into probably 4 parts up until Thursday itself. We're going to try and cover the 1,200-page motion for post-conviction relief, hopefully, and get you guys as much information about that and analysis about that before the brief comes on the 20th of this month here, which is basically coming Thursday here. So that's what we're attempting to do, trying to give everybody an idea of what's going on here, what's gone before, and that sort of thing. Ali Apperson will be joining us also at some point to kind of offer some of her analysis on this, because she's obviously very, very up on the case. She knows a lot about the case, a lot more than most people, I would say. And so she will be here at some point to also be able to offer her point of view and that sort of thing on this. So without any further ado, we can move over to Travis's documents. For everybody, we can start pointing out what's important here. So this is the first page of the motion for post-conviction scientific testing, as you see right there. It's the first page. Just a couple things that Travis wanted to point out about this is, number one, up at the top there, you got the case number, which is 2005 CF 381. I would imagine that has something to do with the fact that it was in 2005. It's a criminal file, and it was the 381st file created in 2005. If I was to guess, that's my guess at what those numbers mean. But basically, it gives the case its own significant identifier. Then we have the date that it's filed, which in this case was August 26th of 2016, which, 3/4 of the year is about 3/4 through the year. Anyways, that was in 2016. That was essentially about 8 months after Making a Murderer came out, maybe 8.5, 9 months right after the first Making a Murderer came out. I believe Kathleen Zellner signed on as Stephen's lawyer in like April or May of 2016, I think, is when she eventually watched it and got involved. Are you showing us when she became the attorney of record?
This one doesn't indicate it's the other appeal. Keep going.
But anyways, vaguely in my memory, I remember it being right about that time in 2016, because I was following the case since January of 2016. So it was right about that time. So she took about 4 months to get a little bit more familiar with the case, and then she filed, let me test this stuff. And then obviously it's filed with the clerk of the court in Manitowoc County. All of this is done in the state court. So I know it says circuit court, and some people might make the mistake of saying, oh, circuit, like the Seventh Circuit. No, that would be a little different. That is a federal court. It's a federal circuit court. So it'd be a little bit different than a state circuit court, just to make that little differentiation so people don't get confused by what they, learned watching Brendan's proceedings go as they did. So that's what we want to point out here. And every time you're reading one of these documents, we're pointing out the date to you, because obviously the date on the next document is going to show the progression of a kind of a timeline of events, sort of. So wanted to point out those couple things. And now we'll move down a little. So first thing here is that it's talking about the Wisconsin statutes that she's basically using here to claim the right to do her scientific testing. I think I'll let Travis explain the statutes a little bit.
Okay, so just 20 seconds about what it is we're trying to do here. This is the case file chronology on the appeal, and here's the big date that we're all talking about. Key deadline 12/20/2018, next Thursday. And our goal here is hopefully by Thursday, for those that are interested in having a thorough understanding of what is going to be filed on Thursday, we need to go back in time, get you up to speed. What she is appealing is the order of the circuit court. This is the order denying the motion for post-conviction relief. That's the next major document that we're going to be discussing. But what led into that Erekose just mentioned is it started here. So what she is asking for in this motion filed in the trial court is for post-conviction testing, and that's provided by a couple of specific statutes and also a case. And at this time, she put the other appeal that had been filed, she put that on hold. So she took over this case 11 years afterwards, after the trial was over, about 11 years. And now she's trying to get this into a position It's really analogous to a sculptor. You know, you think of the greatest sculpture of all time. For me, it's David by Michelangelo in Florence. And it, you know, starting off just carving away huge pieces and then smaller chisel to finally, you know, he's finishing that thing with literally sandpaper. And hopefully, as we look at these documents over the course of this week, you'll understand that's what she's doing. So what she's doing here with this motion is she is laying the foundation. She's picked up the case. I wouldn't even say midstream. It's like 9/10 stream. It's already been up on appeal once, already been to the Wisconsin Supreme Court. That appeal was denied. And then Stephen literally takes over. We see that in MAM 2. They get the boxes of documents, and he's trying to go through this stuff in his cell, his jail cell, prison cell. And then they get the call from Zellner saying that she's going to take the case. And so one of the first things she goes through and she says, you know, I think everyone's had a misapprehension about what this case is about. This case is about a lack of understanding of forensic science, poor forensic science in the trial, et cetera, et cetera. So she decides what I need to do is get my experts in here and look at it. So that's where we're at.
Okay. So, and obviously to not display the fact that Mr. Avery will be incurring all the costs of that testing. In other words, Kathleen Zellner is fronting the money or putting up the money for all that testing. So it doesn't cost the state anything to allow her. So these are all the things that she's doing to be kind of open and transparent and saying, like, you know, look, and there's going to be another example kind of her using tactics that are more likely to make the state agree. But this one, I think, is a huge one too, because it's like, it's not going to cost you a thing. All you have to do is release it to us. And whatever the cost that it costs you to send a deputy down and pick up the evidence and bring it to us is all the cost that it's going to be for you. Right. So that's a huge factor in, you know, her being able to get whatever she wanted to test. So, and to me, it's another reason why you got to question why they're kind of holding back the RAV4 the way they are. When she's, you know, especially when you see the later example where she's given the state every reason to want to give her the evidence and have it tested, because to put it another way, you'll see it later, but I'll give you briefly what it's about. She determines that the laboratories that she has do the testing aren't going to just report it back to her and then she gives it to the state. She actually lets the state know that the information is going to come straight from the laboratories themselves to the state, and they're going to report directly to both sides, not to her side first, and then she disseminates the information to the state. Another reason why to give the state incentive to want to let her test, because by doing that, she has no buffer. If the evidence comes back against Stephen, it goes straight to the state. She has no way to do anything about it. So that makes it an enticing option for the state to want to go forward with the testing. And the fact that they're holding on to that RAV4 the way they are and stuff is interesting to me. So, sorry, let's move on.
Great point.
Hi,
there.
Allie.
It's
you have your mic off, by the way.
Great point there, Erekose. It's an enticement, and throughout she's doing a sell job on the state. And this part right here, by doing this additional testing, a guilty defendant would risk conclusively establishing his guilt. And like you say, we'll see this at the end. You know, we could just picture the phone call she's making the other side. Hey, you should be all for doing this testing,
right?
Because if he's really guilty, this is just going to be the final nail in his coffin.
Right. Exactly. It gives them motivation to want to say, okay, yeah, here, yeah, those labs are going to report straight back to us. So, okay, yeah, all right. They'll do it out of the sheer hope that something will come up against Stephen, and there will be no buffer for Zellner to do anything about it. So it makes that to me, that makes it an enticing option for them.
Yeah, she says, you know, there's only one reason he wants to do it, is he's completely and totally innocent. And what we're setting out to do, if you allow us to do this testing, it will conclusively establish his innocence. So that's our goal.
Right.
Establish his innocence, which would result in his release from prison. I just made a quick note here that technically she's incorrect about the first charge. Well, actually, she doesn't say charge. She says, he's charged on the 15th with homicide and mutilation, later amended to include possession of a firearm. It was actually kind of complicated. It started out as felon in possession, then they amended it to add murder and mutilation, but they forgot to put the felon with a firearm back in, and then they corrected that later on. It's really neither here nor there. I've just highlighted some factual stuff that I don't think she's talking about. She's establishing that here in the introduction about the facts that the state had made a big deal that he was the last person to see Teresa alive, and she's pointing out, I've got solid evidence that maybe he wasn't the last person to see her alive.
Because of the cell tower pings, right?
Right. So we'll go down here.
Okay, so which would allow anyone in possession of her phone to access her voicemail, which is another interesting point because we know that suddenly room became available in her voicemail box on, I believe it was Tuesday. Monday was the 31st. Yeah, I think it was Tuesday the 1st or Wednesday the 2nd. We know room was created. I can't remember exactly which day. Room was created because Teresa's mom and somebody else was able to leave a message on her phone. And in order, and another thing is that the phone had gone off the network. It had been powered off, and after 4 hours of being powered off, it goes off the network because it's not sending the signal identifiers to T-Mobile anymore. I believe it was T-Mobile she was with. And because it's not sending those signifiers or those identifiers from the phone anymore, they put it off the network completely to where it doesn't even ring when you call it. It no longer rings. When you call, it just sends you straight to voicemail, which is what it was happening to a lot of people. They're getting sent straight to a full voicemail. But suddenly on, I believe it was Tuesday or Wednesday, her phone starts ringing again, number one, and there's room for people to leave 2 messages. So for her phone to have started ringing again, the phone had to have been powered up, and T-Mobile or whichever network, Singular, sorry, I think it was Singular, it had to be detected by their network, and therefore they were now ringing the phone again. So that's something that I think is interesting and noteworthy.
Okay, so now we're transitioning into our first major, I hate to use that cliche, bombshell, but we need to think of another one. But here is a major
talking point,
a factual assertion on her part.
Yes.
Go ahead, Erekose, and take us through what's significant about discovery of the vehicle.
Okay, so what she's saying here is that on November 3rd of 2005, Officer Colburn discovered the victim's vehicle. Now, there's 2 ways we discern this. There's number one, the call that Colburn makes into dispatch on his cell phone that is played in court by Dean Strang and everything when he's questioning Colburn. And then there's also a document, which is also shown down in the exhibits that are connected to this, that shows us that it was taken into custody on November 3rd and impounded, or however they refer to it, on November 3rd.
So
there's 2 reasons why. Sorry.
Let's just, I made a note here that Exhibit C is page 61. So let's just pop forward there real quick just to see what that is she's talking about. This is a good example, how you check things out. So this is Exhibit C.
Right.
And then it's redacted, but and then so where is she getting this from? I've never seen this. Where's this coming from? And then go ahead, Erekose.
Okay, so as you can see right here, they show right there where he's got the little box pointing that it's 11/3/2005, that the RAV4 is seized into evidence, basically, and it's a Toyota RAV4 sport utility, and it's green, dark green. Don't get me started on the whole turquoise or aqua blue or whatever. But anyways, it's dark green still at this point. And anyway, so that's clear, definitive document, by the people doing this investigation, telling us that it was seized on the 3rd. We also know, interesting point, there's also a similar document, just like that one, where they are reporting Stephen Avery to the FBI as a murder suspect on the 3rd of November. And that is just bizarre because it's like literally like 55 minutes after Teresa's mother called and reported her missing. And they're already reporting Stephen to the FBI as a murder suspect. They have no bones. They haven't even found the RAV4 yet. And they're already doing that. So it's an interesting thing to point out. On November 5, the vehicle was discovered. It was moved to the southeast corner of the Avery property on the evening of November 4 of 2005. After the Calumet County Sheriff Poggle, the investigator Wendy Baldwin conducted a flyover of the Avery salvage yard, and that's so we all know that flyover. We really never saw the RAV4 in that flyover, but it's also whenever they start panning the camera towards that corner of the yard, they do it in a way where they don't show an approach to that corner. They only show after they get past the tree line and kind of try to look back, and like the trees obscure that whole corner so that you can't really tell what's there and stuff. It's really strange in that flyover. Bugs the hell out of me when I watch it. So anyway, so that's what that's saying. And then we move down to where or is there something else you want to talk about the flyover on that?
I just saw some comments in the which is I'm looking at my phone from the live chat.
Right.
People indicated, well, I'm disappointed. It's can't be any new evidence and whatnot, and that's true. But I want people to keep in mind this is just the motion for new testing. Then she does do new testing, and we'll go over that on a later date. But
remember that this is a very early on. This is, like I said, in August of 2016. She is just asking for the stuff to be testing or to get it tested. Once she starts testing, she starts amending theories. She starts changing things and everything so that she gets what she's eventually going to go with to be as refined as possible with what she thinks really happened. This is just the starting stage, and this is going to, like I said before, morph and change until it gets to the present day. But what she's doing is putting a lot of things on record, and that's how she's able to come up with little surprises later on in the appeals process, is because if she makes every possible thing she can as part of the record and she needs it later, it's there. It's important to have things be part of the record. And
that's the analogy to a sculptor.
Right.
What she's doing is sculpting this thing, and Allie's right. She can't bring in new stuff after a certain point, but it started October 3rd that's her appeal. She files this appeal, and then she starts bringing motions to correct and supplement the record. This is about computer records. This is just a quick example. She keeps doing things to, fine tune her sculpture to here's the record is being, that's the cutoff on the record. The trial court on 9/25/2018 sent the record back to the court, 2 boxes of exhibits. That is pretty much the
right. But up until that, she was filing, amendments and supplements and all those sort of things. That's how we end up getting the prison call between Barb and Scott and Stephen, is because she added that as a supplement and things. She's done everything could possibly do at this point to put everything on the record that she possibly can, so that if she needs it later, she can use it. And that's where her attention to detail is going to be the big deal here. If she has really gotten everything in the record that she needs to hopefully argue this on appeal.
So that is correct. New stuff cannot come in, but she able to roughly mold it the way she wanted it for her brief, because she knew ultimately she's going to have to file this brief on the 20th, and she's just trying to make sure she's got a solid base for her sculpture. Here she noted that the coroner was not informed. We saw that in MAM 2. So
Right.
she's, and this is just laying a factual background to get the testing. She's not locked into any of this, and we'll actually see that here in just a little bit. I didn't have anything else to comment on what I highlighted here.
Just the fact that I know a lot of people also find that to be a very fishy part about the coroner, and I agree. It always has been a strange thing to me, because if it was such a busy crime scene, everybody was so busy that Ertl couldn't even be there for the bone collection and stuff. Why are they turning an experienced hand away? I mean, that's always one thing that, besides all the obvious problems with them turning her away, that's always been an additional one that I kind of had an issue with.
Right.
Because
I was just watching a video today that Allie did about what they actually did do in the evidence collection relating to the bones. And Allie lays it out really, really well, how badly they screwed that up. I mean, badly. And the fact that, they didn't have her, and we now know that she had contacted excellent forensic anthropologists to come in that she had worked with on other cases. Allie pointed out in her video that the person from DCI that they had brought in specifically for bone evidence wasn't contacted in time. And, it just was horrendous what they did in terms of the collection. So, she's making a note of it here. Why? Because, she wants the court to understand she really needs this additional testing if you want to ensure that Stephen is afforded all of his rights.
Right. So now it gets back to talking about Link and Colburn again. So either Officer Link or Officer Colburn were connected to the discovery of each item of planted evidence. As we were seeing before, Colburn seized the victim's car on November 3rd. The reason why she says that is because you've seen the document already, that it shows seized on 11/3, and we all know about the call of Colburn into dispatch from his cell phone, where he calls in the Sam William Henry 582, and comes back to Teresa Hallbach, right? So we all remember that. So that's what she's talking about here, and obviously we know Link and Colburn are there for the finding of the key. Just almost every major piece of evidence, those two are there. Charred bones.
What's significant about this, and why I made this note up here, is she just comes out and says it. They planted evidence. That's very unusual, but that's very, very strong. But she backs it up and just say, "Oh, they planted evidence." She's backing it up, and again, to get the court to let her establish one way or the other. Either I'm totally wrong, and this testing is going to show I'm totally wrong, or and that Stephen is absolutely positively guilty, or it's going to come back and it's going to show that there's significant problems about the origin of this evidence and the timeline that was presented by the state at his trial.
And I believe so. Yeah, it shows that Link, what that's talking about there, Officer Link was conducting a search of the garage. It talks about how they have Link and Colburn signing into the property on March 1st and 2nd, and are there even on those days when evidence is found again. So, and like I said, they're actually on the sign-in, sign-out logs. So that's the exhibits that they're calling out right there. So I just thought I'd point that out to everybody.
And before I forget, I'd like to, I know I will. big shout out of personal thanks to Allie, who I send drafts of these and what we're going to be preparing over the next few days. I sent drafts to her to review, and she pulls out stuff that I haven't considered. And on this meticulous researching, like, for example, pulling these documents up, there's just no way we could produce this and get this out for everybody without Allie's help. So thank you so much, Allie, for all you've done so far, and all that, we hope you can help us with over the next few days.
Absolutely. Right. Thank you.
So what we're going into here now is she's, got a couple of suspects she's bringing up. Go ahead and take over.
Right. Individual A, obviously, that's the way she was referring to it at first. And individual A would be Josh Redant. Okay, now those of you who have watched MAM2, you remember the name Josh Redant. He was in there, and Zellner talks about how her investigators went and talked to Josh Redant. So, but what she's talking about here is that, that Josh Redant accessed the property from the quarry 4 times for some unknown reason, and this is when she suspected him. So that's why she's talking about it this way. We now know that she's talked to him, and she no longer considers him a suspect. So obviously there is no more individual A as we look at it at this case in this whole thing in the present day. Individual A, or at least individual A, has changed to another individual. Anyways, so that's what that is. And it's just pointing out how he had been accessing the property. And the thing that ended up being interesting about that is the fact that he could access he could come up right behind Steven's trailer on the property through a road. And he came up and talked to Steven a couple times, from what I understand, that way, using that road. And so if he could use it, others could use it. So that's the important thing about Josh Redant. So we'll move on now to where it talks about individual B here, I believe.
Yeah.
Unless you guys have something else
before
to say
we go
about
down to individual B, so keep that in your back of your mind, Redant, and where she ends up by the time of her motion for post-conviction relief in June of 2017. And I think we're going to see a major change there. But initially, we've got individual A, and then here's everybody's favorite, individual B.
Individual B, Mr. Hillegas. Good old dodgy Ryan, right? Anyways. So we got individual B. Accused access the property using a false name, civilian search map attached. Individual B misrepresented the victim's blinker light was broken months before. Obviously, we know that's not true. Insurance companies come back. That didn't exist. Individual B received approximately 22 calls from law enforcement on November 4th, which would be Friday night before the RAV4 was found. 22 calls from law enforcement. That's and by the way, this guy cannot remember a single name or face from law enforcement when he's on the stand getting questioned about it in court. Not any, barely. I think he acquiesces to knowing who Sheriff Poggle is, but he can't even remember who the lead investigator Wiegert is. So that's the dodginess of Ryan. But anyways, yeah, 22 calls from law enforcement, but he can only remember Poggle's name and face. So I find that interesting. So then we have Mr. Avery contends that the victim's keys and bones were planted on November 7th of 2005 and were discovered on November 8th of 2005. Let's see here. Dr. Eisenberg also admitted that bones had been moved prior to their location in Mr. Avery's burn pit, which is something that all bone experts in this case agree. They all say bones moved. There's only a difference in directions as to those bones moving, in my opinion. Obviously, Eisenberg for the prosecution says they moved from the burn pit to elsewhere. And then the defense's bone expert says that they moved from elsewhere to the burn pit. And we now have 2 experts saying that that's what happened on the defense side. We have the one that testified at trial. Yeah.
I just want to say that real quick. That is what it says.
Yeah.
Falcon.
So. All right. So searches.
I just laid out that, we all know that, there were multiple searches of
multiple hours.
His trailer and garage and some things were discovered some days, and some, others were discovered later. Why weren't they found when they were originally searched? But
Yeah.
I just laid that out.
There's 8 latent prints that don't match Avery or Dassey.
Or any of the other family members,
Yep.
not including Scott.
Yeah, so it makes you wonder whose prints they don't have, right? That's basically what makes you wonder, I think. But also to talk a little bit about what was up there above is the multiple searches and how everybody tells you that they were just cursory searches and blah 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 blah. No, those searches were, pretty long, especially the one that's 2.5 hours. You're searching in Avery's bedroom for 2.5 hours. Look, you've scoured that. It's a like a 9x9 box. It's not a huge area, and yeah. So, anyways, that's significant amount of search time there. I just wanted to call attention to that.
And so she knows this is important, and that the state tried to deflect this by saying, "Oh, it was cursory search." And so look how meticulous she is, and she does this from logs, 2.5 hours, and this and that. She's laying it out very meticulously, the amount of time that these searches took leading up, obviously the big stuff in March. Now we're to the prints and blood in the car.
Right, which is what I was just saying is how, these 8 prints obviously didn't match Avery and Dassey. So whose were they? And they obviously didn't match Teresa either. So whose were they? And that is a significant question that didn't get answered. And you got to wonder why that question didn't get answered. Let's see. Officer Colburn conducted an hour-long search. An hour-long search in that bookcase, approximately 32 by 16 by 31 inches. An hour. Okay. And then suddenly he's shaking it, and the key magically pops out of Narnia. Right. So yeah, it's ridiculous. It's absolutely ridiculous. If he spent an hour on that tiny little cabinet and didn't find that key wasn't there.
She's just a brilliant writer. This is literally read in between the lines here. An hour to search something that size just doesn't make any sense whatsoever. And then, again, she cites right to the trial transcript that, this is a problem. And then, again, the context of this is she's trying to get testing.
They had to figure out how they were going to do it without, Kucharski seeing. If, Kucharski was there observing them, right? So they're trying to just figure out how they're going to do it without him being wiser, right? And I don't think they had anything to worry about because he seemed pretty thick. But anyway.
So then the significant thing I noticed, we want to keep this in the back of our mind. She's saying that their experts said there was masking. And that's why you didn't see her DNA and so on. And, I suspect we're going to see this in the motion for post-conviction relief, and we're going to see it in her brief. But it's just something to keep in mind. There's a reason why she's setting out what their testimony is.
Right. Yeah. That's about the blood on his finger. Right. And he's throwing Teresa into the back. He's supposed to be actively bleeding, and then literally throws her into the back of the RAV4, yet there's none of Stevens Avery's blood in the cargo area of the RAV4. So yeah, that is an interesting point. Absolutely.
I just pointed out here's, another, it's not 1 or 2 or 3 simple errors. It's in excess. I've got a log of them, of significant errors in the investigation of the case. Here, she's pointing out, I can't remember what number this was in my list, number, 54, what, it doesn't really matter.
Right.
She's pointing out errors, significant errors in the investigation. Here I'm just marking exhibits that I want to check out.
Right.
Then here's just an example. It's hard. It's just, the record is so voluminous. There's so much info. There's no question that the searches were March 1st and 2nd. She even, and this gets corrected later on in her motion, but it's just wanted to point out, we'll see a change there. Here's the stuff about the exiting, if you want to talk about that at all.
Yeah, certainly. We saw in MAM2 where they got some bones that were approximately the same density and thickness as a human skull, and attempted to shoot through multiple layers of it to see if a 22 bullet really would exit the skull, or how often or likely or probable that actually is. And so we saw that really wasn't possible. It goes through the first one, it goes through it enters, but then it doesn't break through the second piece. And most of the time a 22 just ends up, ricocheting around the inside of the skull. So that's an important part, because, they're saying that this bullet fragment was what killed Teresa, that shot her in the head. And yet it has not a single trace of any kind of bone on it. It has wood and paint. That's just odd and strange. So,
yeah, we now know wood and paint, but again, we
didn't know that at the time though when this happened. But yes, right.
That's why she wants to do this testing. What is on that bullet?
Yeah, absolutely. So she's looking for, obviously, the items of the RAV4 here. She's like, we want to swab the hood prop. We want to swab the the battery cables. We want to swab the interior hood release, basically, because if he's leaving nearly 2 nanograms on the latch, he should have been leaving a comparable amount on those other things when he touched them, right? And that's what she's basically moving forward with there by wanting to call out, her testing on the RAV4 that she wants to perform, because and as I said, the more they obstruct it, the more guilty they look, in my opinion. Let's see, EDTA. The EDTA, just to explain to everybody, the EDTA testing is no longer Zellner's theory. Look, she doesn't believe that the blood came from the vial. I know some people out there still do. I still love you. I'm not mad at you. I'm just saying that Zellner has abandoned that theory. She doesn't, she's not with that theory anymore. Her theory is the blood came from the sink, and that's the way you're going to see her talk about it from now on. Basically, her expert that she was going to have test the blood for age testing to find out approximately how old Stephen was when the blood was taken. And that was what she was going to try to use to prove it was planted. But as it turns out, it was just too degraded. The expert that was going to do that particular testing, that had pioneered it, said it was just not going to be possible with the samples that were left. So that's what happened there. The radiocarbon.
Basically the same thing. They weren't able to do the 14C testing. And I just wanted to point out that, what she originally wanted to test and how she wanted to test it, some of that wasn't possible to do, at least to forensic science standards. And so, we're going to see, this is going to be another example of how things evolve from this motion to the motion for post-conviction relief.
Right. Yeah. Right. So, and like I said, we're calling attention to the way that she has morphed and changed her kind of narrative, or it's basically an evolution of her theory as it's gone along here, as new evidence came in or test results came back, and has other things surfaced. The jail call between Barb and Scott and Stephen happens, and all the various things that begin to happen that create, all this. She's been amending and supplementing and doing all these things because she didn't just nail it on her first try right here. That this wasn't the end of it. This was just the beginning, and it is. I can't call enough attention to the fact that it continues to morph and change as it went by. Now that she's filed and now she's with the appeals court, she has less ability to morph or change anything. She's got to hope, and I think she's done a pretty darn good job that she's put it all on the record and that it's all going to be there. And so when she needs to pull that bag, or that trick out of the bag, or that piece of evidence out of the bag, that it's going to be there for her. She's made it on the record for her to be able to use it effectively for her client. That's the big deal. So retesting, let's see, new and improved DNA testing, previously untested items, the license plates, the swabs from the victim's car.
So just an example, this is why she wants the car, and this is, leads into why are they resisting this?
Right.
So, she specifies this is what she wants. This is why she wants the car. These are just examples.
Right. Blood testing on the hood latch, right? Which we now know they did that testing, and it's not any bodily fluid, which leaves epithelial cells.
And she wants the key, the actual key.
Right, the RAV4 key. Yep.
Because she wants to get into this masking theory that Colhane testified at trial about.
Right.
Wants those license plates
Okay.
because she has more sophisticated testing. See if they can get touch DNA because she suspects, that's going to be somebody other than Stephen Avery that has a connection to the case. So if Colburn's DNA comes back on that, or links, or suspect B, or whomever.
Right. Individual B.
Now, and then going back again to her point, if the only DNA, if there's Stephen's DNA on there, then it's game over. And so the state should be all for this stuff.
Absolutely, they should. Yeah, as I was alluding to earlier, she says in this briefing that the state should be inclined to let it all go and happen because the results are going to come back to them and us, not to us and then to them. So that makes it advantageous for the state because everything they get is going to be straight from the laboratory, and it's not going to be colored or edited or anything else. It's just going to be the results. And if those results are unfavorable to Stephen Avery, then that's advantage to them. So that's a ploy by Zellner to make this even more enticing to them to get at the truth. She's basically saying, I'm trying to get at the truth. You guys want to join me?
So, she wants, same reason, she wants this blinker light. Obvious that reasonable assumption, the individual handled that blinker light. This goes back to her theory that that blinker light may have been damaged trying to push a vehicle out of the way to get into the salvage yard during planting. No one's tested the lug wrench. She wants to get all over that.
Yep.
Different areas, she's all over those battery cables.
Yeah, she wants to swab the battery cables, the interior hood release, the door handles, the hood prop, just all that stuff that Stephen should have been touching as he was opening the hood. If he left nearly 2 full nanograms on the hood latch, then he should be leaving approximately the same amounts on all those other things that he was touching. If there's nothing on those things, and yet he somehow miraculously leaves nearly 2 full nanograms on the hood latch alone, well, I think anybody here can use deductive reasoning and see the problem with that.
So here's something, maybe Allie can speak to some more, but, here's, you just don't hear a lot about this. And so this is another thing, the item CB, purple thong, that we need to keep in the back of our mind and find out, what ended up happening with this? How was it mentioned in the motion for post-conviction relief, if at all? Was it provided to her so that she could do this testing? If not, why not? Does this end up being an issue in her adult brief filed on the 20th? Because as far as I know, Allie and Erekose, this has kind of got lost, this item CV. I haven't seen much mention of that.
Yeah, I hadn't either really, but
Yeah. And it's kind of like the male DNA that was found in the quarry, the blood, that when you hear about it, it wasn't tested. It didn't match Stephen and Brendan
right.
or the
And that's what-
family.
right.
But what did they do with it?
And
It just
Zellner
kind of
wants
drops
to-
off.
Yeah, and Zellner wants to get her hands on those because she wants to see if there is a trace of male DNA there that doesn't match Stephen and Brendan as well. Right. Absolutely.
Yeah.
So
There
this
is.
is one of the things she's kind of holding back on, and this would not be new evidence. So she, devoted a couple of pages in her brief to this item. It's just, kind of one of those, what we'll call a sleeper theory.
Right.
This, it's in the record.
Something that got missed previously. Right. But it's still on the record. And therefore she could argue about it. And it would seem kind of new, but it's actually been there the whole time. Right. That's what you're getting at.
Yeah, exactly. And so, and item A is, another new testing. I want all of this stuff because it's never been tested before. And we want, to find out the person who last was in that car, who disconnected the battery cable, should have been leaving DNA. Hear a lot about those pelvic bones, right?
Yeah.
Somebody representing somebody that's guilty, and this stuff, they don't go out and say, I want the pelvic bones. I don't want to look at them. I don't want photographs of them. I don't want the Wisconsin lab analysis of it. I want those bones in my guy's lab. And then we'll know. We will know.
Right.
Again, suspect A, this kind of dropped out, and it may be because she was able to do some of this testing combined with straightening out the issue on whose property that actually was, and then being able to meet with that individual and his attorney. And then, she goes into, these are my experts and what their background is.
Right.
Travis,
Yes, ma'am.
a lot of people have a question, and some in the chat right now as well, but I've seen this question asked a lot. Why does Zellner not have access to this evidence now for testing? Why does she have to get permission, go through all this crap? Why can't she just have it? I know the answer, but they would probably like to hear that.
Yeah, it's a really, really good question. Basically, what Erekose mentioned in the beginning, part of this was a sales job for the state to say, hey, this is why you should be all for testing. If he's guilty, this is just going to be the final nail in his coffin. And so we're really at the part, what testing was done, why it was done, and then, why other testing, wasn't done. So there was a prior court order. Every state in the country has a DNA testing statute. Wisconsin requires that anything that might contain DNA be preserved forever after a trial. And then it also provides that a prisoner who's been convicted based on DNA evidence later on can ask for independent testing. And so way back in 2007 with his first appellate counsel, they had got a trial court order put in place that provides that they'll preserve this evidence according to the statute forever. you know, the stuff they got about EDTA would be preserved so that they could go in and look at that later. They had this order. And so back to the original question, you saw in MAM2 that she started negotiating with the state, and the state started agreeing to for her to test certain things. And she said right in there, it's always best to try and reach agreements on this stuff rather than litigate it. Why? Because if you have to litigate over it, it exponentially adds to the time that's required. So they started coming up to agreements to get stuff tested, but they reached an impasse on other items. And the judge never ruled on this motion. She kept getting notice that they'd stipulated to certain testing. As a matter of fact, they were in the middle of having more stuff tested when she just on her own out of the blue denied the motion for post-conviction relief. And so that's why it didn't all get tested the way she wanted. And it's going to be, and this is what y'all need to be looking at on the 20th and the following days is, what is she saying she wasn't allowed to test, and what the court should order if it's remanded back in terms of testing.
Wouldn't that be basically giving the court an option to open the door for her again instead of slamming it shut on her?
Yes.
Awesome. That's a possible outcome, folks.
Yeah, and I think her brief, you're going to see all throughout that she's talking about this should be sent back for these items to be tested, and that an evidentiary hearing be allowed on those specific items.
That's what everybody should be hoping, is that if nothing else, that at least the appeals court allows her access to the RAV, because what that will do is it will at least keep her in the game. But hopefully they're going to allow an evidentiary hearing. But let's hope that at least, at the very least, by listening to her argument, they grant her some more evidence to test. It's pretty obvious the state is reluctant to give it up, so I'm pretty sure there's going to be something juicy there. I'm fairly certain at this point.
Yeah, I think go ahead.
So really, at this point, they have to negotiate what we want to test this, and she'll grab a couple of things that she would like to start with, and they negotiate back and forth, and they come to an agreement or don't, and then do testing based on that, and then ask for an evidentiary hearing on that. And when they get to the point of the evidentiary hearing, then they have access to everything, right? Is that correct?
Yeah, except so they were doing negotiating up until
Angela Sukowicz denied the motion for post-conviction relief,
which was October 3rd, right. And then the so now there's no more negotiating. Now she's going to file her brief, and she's going to, part of her appeal is going to be, this case needs to be remanded, at a minimum, needs to be remanded back to the court for these tests to be done. She's also going to argue, hey, I've got enough in here that it entitles him to a new trial right now without any evidentiary hearing. Then she's going to argue in the alternative.
Right.
And the lawyer phrase for that is,
if I don't have enough for a retrial right now, then I have enough for an evidentiary
hearing.
Right.
And if I have, if it does go back for an evidentiary hearing, you know, these tests should be ordered to be done prior to the commencement of the evidentiary hearing. Otherwise, we're just going to be right back here where we started. So, Allie, yeah, and then.
So basically, she knows
briefs, you know, then they can start negotiating more, but now that it's at the appellate stage, the parties have less control over it.
Mm-hmm.
They have less, both sides may see, well, let's just wait and see what is the court going to do on this. And that's exactly what happened in Making a Murderer 3, or Making West Memphis 3 is, it went up. The state was saying, no, you're not entitled to any more testing. And, they went up to the appeals court, and the appeals court said, no, you're wrong. They are entitled to testing. They're entitled to an evidentiary hearing. And it got sent back for an evidentiary hearing with a new judge. And that's when they reached the deal for Alford pleas.
Right. So when it goes back to the point where she is going to either have a new trial or an evidentiary hearing, then at that point, she'll probably get the RAV4, but not up to that point, because that's one of those things they're not going to agree to, I'm sure.
Correct.
So I think everybody's wondering, why doesn't she have the RAV4 now? Why won't they give it to her now? Why can't she get it now? And I think that's why, because they won't let her have it. So later,
it's in their possession. It's in their possession and control.
Right. She will get it later. Don't worry.
But the appeals court could order it.
Oh, absolutely.
Mm-hmm.
Right. So that's, that or other things. They could order other testing. Instead of granting a new trial, instead of granting an evidentiary hearing, there's hopefully a third option where they grant her more testing. I'm just saying this guys gives her more avenues for success. Is basically the only thing I'm trying to point out by saying that. If they grant her the ability to test things that the state is denying her, they override the state and she gets it.
Exactly. So what I'm skipping over there was testing related, because I actually have to get off here in about 2 minutes. Stuff that she abandoned because it was degraded. So there's no sense in going over radiocarbon testing, because that ended up, her expert told her it wasn't going to be, scientifically reliable. So she does say she wants to do trace testing, and we're familiar with microtrace. They're the ones that examine the exemplar bullets.
Part of the deal they were trying to make was Skip Palahniuk wanted the skull fragments because he saw something in the radio spectrography that he was very eager to get those skull fragments under his microtrace microscopes because of something he saw, something he suspects. And I'm very keen for him to get it.
This is something, another back of our minds, was she given the actual key for trace testing? I know she was given FL. There's a lot about that. I don't see that they ever gave her the key to trace test.
Mm-hmm.
Now here's something, if this is just from a lawyer's perspective, this is just pure appellate genius, legal genius. She's asking, for an item that would conclusively establish that the swab was planted. We've all seen Allie's video, or hopefully everybody's seen her own experiments on swabbing her own vehicles and what they look like. And we're going to see another great example. She did the ballistic stuff. Here's another major error. What are we up to now? 75. This is huge. So they're you should never have two evidence
two things labeled as one number, right?
Because that is one of the big red flags on losing evidence, planting evidence. Just having the numbers straight is a huge thing. Well, there's two items that are listed as 8436 in this case. Are some of the bullets that were found in his drawer in his bedroom, and it's also 3 knives. Also have that exact same they used, that's just an example of,
Right.
the, you know,
Mislabeling and
mountain of critical
confusing.
errors in
Yeah.
this.
Makes everything a lot more confusing. Trust me. Try to track the bones through queso, folks. You'd about be wanting to shoot yourself by the time you're done and trying to track down all the misentries and all that sort of stuff. It's ridiculous.
So I'm gonna go with this and finish, and then, but I'm gonna scroll it down to the conclusions,
Okay, buddy.
so you can talk about this. But you know, check this out, and I'd really like everybody to go back and look at this. We're 42 of this motion, talking about the second Motorola phone that was supposedly found in her house. And look what she says here. It says, we want this for our own testing. We want the actual phone. We don't want a photograph. We don't want, you know, pictures or video of it, because she says why. The phone was allegedly discovered in burn barrel. If we ask for this and they can't produce it, what does that mean? It would demonstrate that the phone was placed in the burn barrel by law enforcement.
Right.
That, you know, again, it's just another example of her sheer genius. But I'm going to sign off here.
Okay.
I'll be just muting the microphone, but you know, in conclusion,
the court, she's just saying that the court should order all this testing for her to be able to do, and they did give her a fair amount, I think, but really that RAV4 needs to be gone through. That's just the biggest question at this point. There's so many mysteries around the RAV4, and so that was the end of that document. So, oh, there he goes. There you go. Thanks, Travis. So, anyways, so this document, as we were talking about, is the earliest document. It's I mean, it was pretty much the very first thing she filed in a lot of ways, first major thing, and she's asking for all this stuff. This is what she knew she wanted to test all the way back then. And look at how pretty much right on she was, because look at how a lot of these things that we saw being discussed here in August in 2016 have panned out and have actually, you know, the testing has actually come out in favorable for Stephen in those areas. So it's like she has a very sharp mind, and she moves right to the things that she's, you know, I mean, she thinks she has a high probability of being successful with. And I think that shows, because a lot of the things she's talked about here have ended up coming to fruition in the recent, you know, motions and things like that. So to reiterate, what we're doing here today, folks, is once again, we're trying to show you the evolution of things. This is the very first motion for the testing. This is asking for the testing. The next thing we're going to go into is, obviously, she does get granted several things, many things to test, and she tests them over the course of the next, I think, 8 to 9 months. And then finally in June or July of 2017 is when she files her motion for post-conviction relief. And that's going to be what, hopefully, you know, Travis and I, and maybe even Allie too, over the course of this week, hopefully before the 20th on Thursday, we'll try and give you guys in segments some of the high points of her 1,200 page motion that will help you guys understand how, once she got the testing done, how certain ideas of hers changed from this to then. And then, you know, after the 20th, we'll try to go into all the supplemental filings she did, so that you guys can start to understand how she was supplementing the record and adding things to the record that she would then be able to use later. So, anything you wanted to say, Allie? Any questions in chat that you think are interesting?
Sorry, there's a train, and I wanted to mute really quick, but
no worries. I can't hear it. Oh, there it is.
Well, there it is.
Hey, we all love trains.
You know, sorry about that.
No worries.
I'm especially interested in how the progression of how it changed from, like, first of all, one of the things we were talking about earlier was how Josh Redant was excluded from this motion here. He was there, and then she was able to exclude him.
Right, because she talked to him and stuff, right?
Yeah, that's really interesting to me.
Yeah.
And probably maybe in like the overview after we go through each one at a time, I think that would be a really cool thing to show, like a list out all the things, how it progressed and changed and where we are right now.
Right. And that's kind of part of what we're doing. So, yeah, it sounds
Yeah,
like you're pretty excited about trying to help us out with this. So I'm very gratified for that.
yeah,
That's kind of what the point is, we want to see, like, she started out with this kind of theory, but then, well, it kind of maybe went this way a little bit, but then, oh, wait, then that guy got eliminated. But then now we got these guys.
yeah,
And, so it's like, hopefully we want to try and show you guys that progression somewhat in a chronological order as she was filing her supplements and her augmentations and her amendments and things like that she was filing all along. She's trying to put everything in the record, everything but the kitchen sink, essentially, so that if she needs it later, it'll be there. And like I said, she's going for a new trial. She may not get that. She's going for an evidentiary hearing. If she can't get the new trial, she may not get that. But I think there's a good chance that if she doesn't get either of those two things, with all the questions there are in this case, I think it's reasonable possibly to think that the appeals judges will go, you know what? Have the RAV4. Go to town. Get your scientists on that thing and let's find out everything you can find out about it. I hope that happens. That's what I truly hope for. And I think if we don't get the first two outcomes, I think that's probably the very least that she should get. And at least that keeps her in the game.
yeah. She said she's just like 2 years into it, and Brendan's like 10 years ahead, so she's still got a lot she can do, a long way to go.
Right.
That
There's
she's a lot of options. So
yeah. So
yeah,
definitely. So that's kind of where we're headed, folks. That's kind
good
of the
stuff.
whole direction. And hope you guys found this video to be informative today. Like I said, for the next few days, I'm planning to probably go live with Travis and Allie too, if she's interested, to cover these motions. As I said, the next one we're going to be looking at is the 1,200 page motion for post-conviction relief. We're not going to be covering that all in one go because, well, for obvious reasons, 1,200 pages is just, yeah. Anyways, this all here took 40 pages tonight, folks. So anyways.
The good news, I think Travis said most of that is exhibits. So it's like 250 pages of,
right.
Still, that's
so
a
I think
lot.
maybe with 4 nights, we might have to skip a little bit here and there and stick to some, really high points. But I think we can get through 250 pages roughly by Thursday. And if we don't, we're going to be darn close, and you guys are going to be having a hell of a lot more information you had than when you started. So that's what we hope to do and help everybody out here. Something that we've obviously been into this for so long, and we know there's a lot of people coming in off of MAM too, and they just haven't been researching this. And so this is one of the best ways we can think to really bring this to you guys, keeping it exciting for you, keeping it fun for you, keeping it so that your eyes just don't glaze over and roll into the back of your head, looking at all these legal documents. I hope that's what we're able to do for you. It's really one of the main goals. Because staying informed is important, but I know it's hard to stay informed when you're falling asleep and your eyes are rolling into the back of your head. So hopefully we've been able to avoid that for you. Yeah. Anything else, Allie, before we go into Stacy Seabrook?
And stuff like that. That's all.
And stuff like that.
I had to say that.
All right. That sounded good. I love it. Okay. So let's put up our little screenshot from earlier while we play out.
Sing along. Be the backup singers.
I gotta get my screen sharing here. Hold on. Oh, let's make that pooch a little bit bigger, huh? What does everybody think?
Yeah.
That dog is awesome.
Cute.
And away we go. It's been a pleasure to have you, Allie.
I'm now
Thanks
here
for having
I go
me.
again. to confine innocent men in a 10 by 10 fates. Oh, neither man deserves. But fear breeds silence in men to walk. You don't say nothing cause you know you're cops, but someone knows something, yet everyone plays ball.
I say we round them all up. Let's brain fingerprint them all.
Everything about the case was suspicious. I hope the biting teeth of justice is so vicious. For those who bred the lie, they temporarily preserve. From time into typos to Brendan's so-called confession, to the fact that Peterson was out of town when she went missing. How can we forget? And they said William Henry Call. I say we round them all up.
Let's brain fingerprint them all.
So much planted evidence now anyone can see. The magic bullet and blood in the RAV. And even evidence that defies gravity. The key that turned up 7 searches later with none of her DNA at all.
Let's brain fingerprint them all.
I say we round them all up. Let's brain fingerprint them all. Who's pulling strings? I want to know that top rank. For those who pay attention, all the
bank stank.
And those that are smiling, they always knew who would take the fall.
Kincrats, ultimately.
I say we round them all up.
Let's brain fingerprint them all.
I say we round them all up. Let's brain fingerprint them all.
All right, folks, that's it for today. I look forward to seeing you guys tomorrow, covering this, 1,200-page motion in parts, segments. Not trying to overload you guys. Seriously, we're going to do this gently. So if you haven't already, it was also a pleasure to have you, Ali. Thank you for showing up. I don't know if Travis can hear me, but it was great to have you as well, Travis. And if you haven't already, please hit subscribe. And Ali's waving at us.
Bye.
And say bye. Alrighty, guys. We'll see you tomorrow.